Yet another massive update in these copyright AI lawsuits. As you guys know, my law office has filed 2 of these class action lawsuits, and there's a whole slew of lawsuits against AI companies. And AI companies are starting to panic. And that's because there was this massive update in one of the biggest ones, which is against Anthropic. So this had to do with class certification. It really makes me so encouraged for our lawsuits. And I'm going to talk to you guys about why this is literally going to impact you. If you're a music creator, you are likely impacted by what these AI companies, Suno and Udio, did. But let's talk about Anthropic first. So for these class action lawsuits, right, this is not about going after AI companies as like AI is bad. It's big corporations that have raised hundreds of millions of dollars and yet willfully, spitefully are very indifferent to your rights and just take your stuff. Okay. So we have a problem with that. But in the Northern District of California, having to do with these authors that sued Anthropic over the illegal taking of their books, they've been seeking class certification and they just got it. And again, this is really exciting for our lawsuits because of how everything seems to be kind of coming down and it is sliding towards what we have been saying since the beginning of this and in support of our claims. So basically, the judge in this case and with this ruling said it's pretty straightforward in the class certification in order to prove the harm that he calls Anthropic's Napster style of downloading millions of works. So again, in this case, it was books. In our cases, they are songs. But either way, what we do know is that we're talking about tens of millions of, well, songs in our cases. And in this case, it was books. So they had downloaded the books from these private libraries and done it from at least 3 libraries that were identified. So what was interesting is that the judge was a little bit pissy in this ruling and just very like not having Anthropic's arguments. And so I thought it'd be worthwhile for us to actually go through, do the deep dive. If you love the deep dives, be sure to subscribe right now. Give this video a big thumbs up and let's jump into it. So where I want to start with this is that in the court's order, it talks about superiority. It's one of the elements of proving class certification, but the court goes, superiority is met where there is insufficient incentive for any individual to bring a solo action prosecuting his or her rights. So in our demand for class certification and request for class certification, we just go for the arguably tens of millions of independent music creators that had their music stolen. Well, not a whole lot are going to be able to bring individual lawsuits against these companies. So that really bolsters our argument on we need the class certification so that there's just the option. You don't have to opt in. You don't have to be a part of this. But if you want to be a part of this and you don't have, let's say, the finances to hire a lawyer to sue on your behalf, that is why the class certification is so very important. All right, so basically you won't have a good opportunity to go through and get protected. It also doesn't make sense for the defendant. So the company that's getting sued, because if you're getting sued by tens of millions of artists, well, that becomes difficult. Here, if not brought as a class action, there will likely be no action at all. And in any case, only a class action that concentrates plaintiffs' interests and defendants' resources into one confrontation will present the claims and defenses with a quality commensurate with the issues import. So basically, we need to deal with it all at once. So meanwhile, defendants now sit in a cloud of copyright liability, needlessly assuming it is correct on the facts and on the law. So basically, as it relates to our claims as well, we go, well, what really inspired this lawsuit is that as part of the major record labels, which is a totally different thing, they sued Suno and Udio about a year ago. And in the answers, that's when Suno and Udio both admitted to taking your guys' music. And what they've said, they go, we took music that was on publicly accessible platforms and used it to train our AI. So over the last, year and some change, as these cases have all been going on, we go, well, is it fair use? Is fair use is going to apply? And in this particular case with this court just weeks ago, this court came down and said fair use does not apply when you are pirating copies of books. And that's a huge piece that's real good for our case. So in the analysis of, well, how do you get certified as a class? Who gets to be involved with this? This impacts you as well, but this has to do with the Anthropic case. So let's jump back into this. This is the judge. It will be straightforward to prove the class-wide wrongdoing. In short, counsel can prove defendant violated the Copyright Act by doing Napster-style downloading of millions of works. And I don't know about you, but I'm real interested to see, as part of discovery in our cases, where the songs were downloaded from, right? So how were they accessed? Did these companies go onto Spotify, which is going to be a whole other issue if they did, if they went onto some other platform where that kind of thing is not going to be allowed, right? Did you go to YouTube? Did you go to Amazon Music? Where did they access the music? Because at least in these cases, Anthropic went to pirating websites. They went to places that were literally giving the catalog of books as a pirated download. And that was an important piece here. And actually, the court talks about that here. And I mean, like I said, the court gets a little sassy, but the court goes, Anthropic was like going around to all these different libraries and trying to find a place to get all these books from because it needed a whole lot. And all of a sudden, the government started shutting down these different libraries. So it kind of goes through and it's like the FBI shut down. There was one called Z Library. By then, Z Library itself had been copied or mirrored, and it created the Pirate Library Mirror or Pilami. When Anthropic's co-founder saw Pilami was ready for torrenting, he messaged his coworkers and he said, just in time. And one answered, the library, my beloved. So, essentially they ended up accessing what the court found was 3 different websites, different libraries, and they're downloading PDFs and text files and all kinds of things. And so they go, the plaintiffs have alleged that there were 7 million copies, and I believe it's 5, but let's keep reading. So yeah, plaintiffs allege there were 7 million copies of the books that Anthropic had Napster style downloaded from these 3 different pirated libraries. Anthropic retained all these copies of the pirated books, which is another really important part of the analysis. So the court kind of made this point. It's like the steps of like training your AI, training the AI is transformative. The piece that gets set apart from that is if you've accessed creative works without authorization and downloaded them. You've made copies. So that in doing that, that's the copyright infringement. So the court goes, quite frankly, I don't care if you trained your AI or didn't train your AI or whatever. The pirated stuff that you could have purchased and you didn't, you pirated and you stole, that is now going to have copyright infringement attached to it. So again, really important for our class action lawsuits and our songs. Where were they accessed? Where were they hosted? Did you just download all of the music and then have it on a hard drive somewhere, whether you used it to train the AI or not? Once Anthropic stopped using pirate sourced copies of books to train its AI, its models suffered a quote performance hit. It wanted to recover from this by finding books at least as good as the quote old books quality, end quote, meaning the pirated ones. So let me put it this way. Again, I work with creators of all kinds, and I work with many of you who use Suno and you use Udio. I remember so many of you telling me, you're like, Suno used to be so much better in the very beginning. It was just like incredible. And then something happened. And so when I was reading that, I go, I wonder if something very similar, it hit a performance wall. And that's probably because maybe they stopped ingesting and training on all of this stuff. And so I don't know what they're doing now. Again, these are questions that we have and that we're going to be asking as part of these lawsuits of, well, what are you doing these days with training your AI, which I guess is kind of an ongoing thing. The motion and summary of class certification. Now, plaintiffs move to certify classes of copyrighted owners in a pirated books class and a scanned books class. So actually, the plaintiffs asked for different classes, which I thought was a good idea. And the court goes on to analyze, saying, even having a subclass, creating one is within the court's discretion under the laws to adopt procedural innovations to facilitate management of class action. So as I'm kind of thinking through this strategically for you guys, I'm like, there's going to be different groups of you, from the ones that have your music on certain platforms, the ones that are selling your music on your own websites, the ones that have copyright registrations. There's going to be different groups of you, and it matters for the amount of damages that we can go after, which is kind of what they did here. So this order certifies that, so these are two of the libraries, LibGen and Pilami, pirated books. The class is limited, in this case, to those who had registrations as well as barcodes, so ISBN, on their actual books. So what I'm thinking is for when you guys distribute music, your music distributor gives you an ISRC number. So I go across the board, all of your music has an ISRC if it was distributed to any of these music platforms. That's good. So that's a starting place. A key point is to cover everyone who owns the specific copyright interest in play, the rights to make copies, either actual or if you're a beneficial owner. So basically, if you're like a collaborator on a song, if you have other authors, if you basically have assigned the ownership to your LLC, you're going to be able to proceed. And because the class is limited to those whose books were registered, this is an important piece, registered for copyright. So one of the classes they go is based on the timing. And so let me just put this way. If you got to this point in the video and you're still cruising with me because either you're interested in this case or you are a part of our class action lawsuit, give us a thumbs up, but this is very important for you. I released a video a few weeks ago on showing you how to register your own copyrights. If you have not done this yet, please do this. Like literally today. I need you to go and actually file to get your copyright registrations because I think it's going to be really important. Okay, Anthropic also argues that, so of the authors, they had their copyrights put in the name of their LLCs and the court found that's okay. All right, Anthropic, and I think this is where the court got a little sassy. Anthropic downloaded millions of book files that can and should be proven on a class-wide basis. A list of works stolen in this downloading can be constructed using the methods set forth in the statement above. Instead of millions of separate lawsuits with millions of juries, we will have a single proceeding before a single jury, Napster style. Court going on to say there is no question. Anthropic torrented 5 million. Okay, so yeah, it was 5 million. 5 million files from LibGen, which is one of the libraries. Instead, Anthropic contends that infringement of plaintiffs' books cannot be shown with class-wide evidence. So the court goes through the analysis and basically says, that's stupid. Yes, we can. So the court concludes this by giving a very fast turnaround on this, which surprised me, basically being like, yes, I'm giving you class certification. Anthropic has got to be sweating to the nth degree at this point, because the valuation that was just recently done for Anthropic was around $100 billion. But it's very important when now you're talking about each instance of copyright infringement is potentially statutory damages up to $150,000. You take $150,000 and you multiply it by a multiplier of millions. We said 5 million. That's how you potentially bankrupt a company. So understanding the narrative that's now being created by these courts of just saying, we're not going to tolerate this. You don't get to come in and plead your case of basically your entire business model being, we're going to steal from people. And now that we've gotten caught, we're going to try to hide behind fair use. We're going to try to hide behind copyright law. And you know what? It just seems like these federal judges are not standing for it. And that makes me real happy. If you haven't signed up yet to be part of our class action lawsuits, you can do so by going to indieailawsuit.com or just get on our email list to get updates. And I'll see you on the next one. I'm Top Music Attorney.